We are the Law and Crime Network. Welcome back. I am Kenney Baden. I am taking over from the amazing, wonderful, terrific Bob Bianchi. But you know what? All the hosts here are terrific because we have terrific trials to cover for you on Law and Crime Network. And there have been a number of them this week. This is Dr. Gertrude Juste. She is explaining the wounds now just on one of the young victims, Sean Henry, that was, you can say executed, you can say assassinated, you can say killed. I'd like to bring my guest today in, if I could. His name is Richard St. Paul. Richard, you and I have not been on, but your credentials are so amazing. We would be here till 5 o'clock when I end to go over them. Just an experienced trial attorney, someone who I've watched on our network and you will only see on our network. How are you today, Richard?
I'm doing well, Good to be with you.
Good to be with you. Now, Dr. Juste is explaining to this jury that there was stippling on the back of the head here. Apparently, there were 2 bullet wounds and 1 exit wound from what I've heard so far in his head. One appears to be in the back of the head, and there was stippling on that, which means that the gun was within a reasonable proximity. I'm waiting to hear how close that gun was to his head, aren't you?
Absolutely. Look, this is a forensic pathologist testifying, and basically her role is to determine the cause of death of the 3 victims. And this testimony is going to be very graphic because if someone's getting shot in the back of the head, there are probably pictures that are going to be displayed to the jury. If someone gets shot more than one time or in different areas, the pathologist, she's going to tell them how the bullet traveled and what ultimately caused their death, potentially whether they were in pain, whether it was a painful death. So this is very graphic testimony and insight for the jury about the cause of death.
Right. And one of the wounds she testified to already, she talked about it going through the backbone, which people don't realize, you know, if you have your back of your head, in your neck, your backbone's going up there, which she said would have eliminated his life. I mean, he wouldn't have been able to move, breathe, or anything. That's pretty horrible for a jury to hear and for a family to hear. Let's not talk just about the jury, because even if the family is not in court, they're going to eventually read about it, right?
Well, that's absolutely right. But ultimately, besides the graphic testimony and the details of how the victims died, the question still remains whether or not the defendant did this. So at the end of the day, it's going to be up to the defense to say that there is reasonable doubt that the defendant caused these 3 murders.
But let me take that one step further. If there seems to be a motive of either this was a drug deal, a robbery, or he got close enough to these victims because he wanted to say, you know, he wanted to torture them and let them know they were going to die, you know, you're putting the gun towards their head, doesn't that impact the jury and say, well, you know, it's so bad, maybe I'll let the evidence maybe slide a little bit on whether he did it, or do you think it has no effect at all?
Well, look, I mean, it's all dependent upon, as you know, the witnesses. This could just be a circumstantial evidence. We're going to see more in this case in terms of what evidence the prosecution has. Right now, we're just hearing about how the victims died, but eventually we'll hear about the evidence that they have on the defendant in terms of charging him with this particular crime. The other thing to take into consideration, obviously, is we all know that motive and opportunity don't have to be proven, but it adds to the story. Prosecutors like using motive and opportunity because it adds to the story of why the defendant wanted to cause these deaths.
Okay, so this is Dr. Gertrude Juste, as we indicated. We've seen her in the past in the Newman Raja case, where she was very effective and really withstood cross-examination. Here she's describing at length the wounds to Sean Henry, who was 26 years old when he was died. Again, I'd like to bring my guest back, Richard St. Paul. Richard, I have a couple of questions to you about this testimony. And there's our poor victim. No doubt he's a victim on the screen that you see him. But a couple of questions to you. Is it too much to go through every single wound at length? Should she have come in here, even though it's a death penalty case, given the most egregious wounds, mentioned the others, and gotten off the stand?
Yeah, look, it's helpful to keep things simple for the jury, especially, but here's the thing. The prosecution, it's the prosecution's witness. So the prosecution has to control their witness. So the prosecution controls the pace in which their witness goes by asking specific questions. And the prosecution can interrupt if they want, but it's really up to the prosecution to elicit the information from the witness and in a very succinct way so that the jury can understand it, not to get caught up in every technicality that the jury could miss.
Well, you know, when you bring a victim into the medical examiner's office, as you know, they x-ray the victim and they'll know where the fragments are, assuming that the plate that they use is not dirty, that they're seeing other artifacts, all right? So she knows how many fragments there are and how many wounds pretty much. Why couldn't she just say, there is wound X, this is the wound that immediately killed him, here's other wounds that were penetrating, but he was already dead, or he didn't feel anything, or they didn't kill him, or they were just superficial. Why can't she say that in a death penalty case?
No, she definitely can. But again, I would say that it's guided by the prosecution, because the prosecution is going to speak to each witness about what they're testifying to. And so therefore, the prosecution would speak to the forensic pathologist and say, this is what we want to say. This is what we want to talk about. And they can, again, control the pace of the witness.
You're right. So this is the prosecution. Now, two things. She's very important in two aspects, right? She collects the evidence and she has a chain of custody. She collects the bullet fragments. She gives them to the police so they can go examine them. That's important. She's also important, isn't she not, in terms of establishing for the beginning whether there's stippling, whether there's soot, to see how close poor Mr. Henry was when he was shot, to see whether it's an execution, where the person was standing, right? Isn't that also extremely important here? And quite frankly, I'm feeling that that's getting lost.
I agree. Look, this is such an important part for the defense, and the reason why it's very important, because the forensic pathologist, the witness here that you see, will look at witness statements and will look at the injuries to determine whether the witness statements match the injuries. For example,
you are brilliant. I have to tell you, my husband is a forensic pathologist, will say that all the time. You can determine whether or not the witness statements are accurate, a la the Central Park Five, right? Even though there wasn't a death. So you are brilliant, Richard. You are absolutely brilliant. Continue. I interrupted you.
No, but obviously that's very important, and we'll cite example. If the forensic pathologist testifies that the shots were entered through the back and then exited through the front of the victim, and then the witnesses testify that they all saw the defendant, Vasata, only in the front, then as a defense, I would say all the witnesses testified that he was in front of the victim. So how can he magically shoot him from behind? And that would add reasonable doubt to the jury, saying that there's no way that my client could have committed this crime when everybody testified that he was in front and not in back of the victim.
So what you're saying to me is the conspiracy from the grassy knoll can possibly exist if the defense does it right. That is the prosecutor, and you develop really, a hardened shell when you're a prosecutor to have to see 5 children who are dead, and the jury is probably going to need PTSD counseling. But Richard St. Paul, my guest, who does a lot of work in the criminal courts in Washington, D.C. and the state of New York, what is the scheme by which a prosecutor has to prove in order to a jury to possibly consider death?
Well, look, each state is different. So South Carolina, for example, has its own aggravating and mitigating statute. And basically, for example, the aggravating circumstances are listed in that particular statute. And to break it down, aggravating means what happened that aggravated enough that was so bad about the murders that this person should get the death penalty. The mitigating would be, this is what happened, and this is the reason the murders were caused because of these mitigating circumstances. For example, in this manner, the defense brought up that he had a mental defect, that he had schizophrenia. Now, the aggravating circumstances in this particular matter would be he murdered a family member, he murdered several people under 11, and he also, essentially
had a common planner scheme, from what I see. What I see is there's two aggravating factors. Right. Now, let me just ask you this. We know that. We know he had a common planner scheme. We know he murdered 5 kids. Why doesn't the prosecution get up there and say, ladies and gentlemen of the jury, we proved to you what the proofs were, and you found him guilty of this, this, and this. Judge, we rest on our aggravation proofs right here, and let the defense go forward. Why don't they just do that?
Look, in a case like this, I would hope that they would do something like that. The reason why is because there's no way to get away from killing 5 children when you admit you killed them, but your defense is, which the jury rejected, that it was because of mental illness.
Okay.
So why drag this case on over and over? And here, basically, this case has been going for a couple of days in terms of the death penalty phase, but we're hearing over and over again, we're learning about the victims' lives, and we're also learning about the horrific crime that was committed.
Well, let's just stop right there. Let's go back into the courtroom and let's listen to some of the prosecution witnesses in this penalty phase, especially some compelling witnesses dealing with Natan, the kindergarten teacher. Oh my God, I mean, this is the teachers of Natan. I mean, I have my tissue box out, okay? The jury has to have their tissue box out, Richard St. Paul. I mean, how can you not, as a juror, be so affected by this that it colors whether you're going to give this man mercy?
Yeah. No, that's absolutely right. I mean, this is emotional testimony. I mean, this is tragic. 5 children, before they had the chance to live their life, they no longer are on this earth. And the testimony you're hearing from the witnesses is basically taking you through what they experienced as children. There were some allegations of abuse, and they were talking about some of the abuse that the children suffered. And then they are talking about, some of the witnesses who are the teachers are talking about their experience with the children, what they like to do, embracing them and hugging them and telling them they care. So they're taking you through the victims. These witnesses are taking the jury through the victims' lives. And it's very
Richard, yeah, Richard, it's so emotional. Then how do you take this tissue and throw it away when a jury has rejected the mental disease or defect that this man had a broken brain, which he clearly does? How do you then get this jury to listen to the fact that his mentality of a broken brain is a mitigating factor?
Yeah, it's very tough. Look, so as you know, the guilty by mental defect, not guilty by mental defect, excuse me, is a defense that is very rarely upheld by a particular jury. So it's not a very popular defense, and it's also not a very successful defense in this country, because you basically have to say that the jury will have to believe that he did not know what he was doing at the time of the killing of the 5 children, that he had no idea that what he was doing was wrong. That's very difficult to prove.
Yeah, you know,
however,
even Tim Jones has his tissues out, his crying rag out. It is just horrible. You know, Richard, we have to take a very quick break, putting even myself together, I'm sure our viewers together. Stay with us, however. We're going back into the courtrooms later, after I can't even talk about it.